Hello friends, today we are going to discuss about euthanasia. This is the part 2 of euthanasia with regard to Supreme Court judgment. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about the second Supreme Court judgment on euthanasia, why the second judgment came, what are the positive and negative aspect of this judgment, and also what were the changes which were undertaken by the Supreme Court in the second judgment. However, if you want to see the first judgment video, it is available on my channel. Let's discuss about the second Supreme Court judgment. First of all, euthanasia means it's a good death, also called as mercy killing. Sometimes it is also considered as physician-assisted suicide. Euthanasia is defined as hastening of death of a patient for preventing further suffering. In simple word, painless inducement of a quick death. If you see the World Health Organization definition of euthanasia, it is a deliberate act undertaken by one person with an intention of either painlessly putting to death or failing to prevent death from natural causes in case of terminal illness or irreversible coma of any other person. With regard to euthanasia, there is no specific law from the Parliament. Hence, the Supreme Court had to make case law. The first case law was Aruna Shanbaug versus Union of India, which was decided in 2011. The second landmark decision was Common Cause versus Union of India 2018. Both these judgments I have discussed in my previous video, that is Euthanasia Part 1. Now, in this video, I'll be discussing about Common Cause versus Union of India 2023 judgment. But however, let me touch upon these important Supreme Court decision, that is Aruna Shanbaug, which was in 2011, and Common Cause in 2018. Here in Aruna Shanbaug, the decision which was taken needs to be kept into the context how the decision was taken. This is the Supreme Court judgment citation. In this judgment, the Supreme Court very clearly said that it is the family member or the relatives or the treating physician can approach the High Court for passive euthanasia. And they need to approach the High Court of the specific state. The Honorable Chief Justice of that High Court will appoint 2 judges bench to decide about the case. This division bench will appoint a medical board consisting of a neurologist, a psychiatrist, and a physician who are well versed in this field. This medical board will examine the person, talk to the family members, and they will give their opinion directly to the High Court. Based upon the opinion of the medical board, the High Court now will issue notice to the concerned people, that is family members and relatives, hospital, and also a copy of the medical board report will be given to them. And finally, the High Court will decide whether to pull the plug or not, that is, euthanasia to be given or not. And also in that judgment, they said, till the Parliament makes the law, that will be the law. This was a very simple, crisp, and fastest method of getting euthanasia. However, there was another important judgment came into picture. That was a Common Cause versus Union of India 2018 judgment. Here, the registered society argued for right to die with dignity. This was an affidavit filed by the registered society supporting the concept of euthanasia because it is a relief from irrevocable suffering of which pain is a factor. Here the important point, they said that irrecoverable illness such as cancer or brain death, of course, Transplantation of Human Organ Act of 1994 has discussed about this. However, euthanasia plays a crucial role here from people who are suffering from coma or else maybe persistent vegetative state. In this judgment in 2018, my dear friends, the Supreme Court clearly said that right to die with dignity has a fundamental right. An adult human being having a mental capacity to take an informed decision has a right to refuse medical treatment, including withdrawal from life-saving devices. This was an important noting. Here it said, any person has right to refuse treatment, but he needs to be in good mental capacity. Further, it also articulated, a person of competent mental faculty is entitled to execute an advanced medical directive in accordance to his wish with adequate safeguards. The right to execute an advanced medical directive is nothing but a step forward for protection of right to bodily integrity and self-determination. Even if he has lost capacity, that advance directive, also called as a living will play an important role. Although 2018 judgment was a landmark judgment, there were many challenges. First and the foremost was registration and storing of this advance directive was a challenge. Implementing of advance directive was very cumbersome and lengthy procedure. The experts to be nominated in the medical board required 20 years. And also judicial magistrate of first class, and it was executive centric. Hence it was very difficult to implement. Hence the second judgment came into picture. However, this time the applicant was Indian Society of Critical Care Medicine. This is the Association of Doctors, asking clarification of this 2018 judgment, approached the Supreme Court. The Supreme Court gave clarification, and this second judgment was pronounced on January 24th, 2023, my dear friend. The question asked was how to simplify the drafting and registration of advanced medical directive, that is executing and storing was the question. How to implement advanced directive if person becomes non-compos mentis? If there is no AD, how to decide the withdrawal of treatment? These were the questions asked. Let's look into the advanced medical directive. Here, advanced medical directive means adult with a intact medical capacity voluntarily can write his will, how he should be treated and how he should not be treated. It should be in a written format, stating when a medical treatment may be withdrawn or a specific treatment shall be given or not be given. And this will take effect only he becomes non-compos mentis, that is when he loses mental capacity, and only have the effect of delaying the treatment with regard to process of death. Here, the person becomes so severely ill that there is no chance of recovery, and he has lost his capacity to decide. That time, the advanced medical directives kicks in. He may undergo anguish and suffering, and further to put him in a state of indignity is the question. That is the time this advanced directive will play a role. Specific terms and instruction must be absolutely clear, and no unambiguous things should be mentioned. And nominated representatives, guardian should be mentioned. And a guardian will take the decision only during the loss of capacity of the person, that is incapable of making decision. More than one AD is there, the latest advance directive will be considered valid. It should be signed in front of two witnesses, that means they are independent if preferable, and attested before the notary or gazetted officer. This is an important changes which was made in this second Supreme Court judgment. In the first, it was judicial magistrate first class. Now it is notary. Attesting authority will check the coercion, and the attester signed with full understanding of all the relevant information and consequences need to be checked. The executor may also choose to incorporate their advance directive as a part of digital health record if it is there. The digital health record is simply ABA card, or maybe a copy of that can be given to his family physician or a hospital where he is taking treatment. Further, a copy of the AD can be given to the nominated representatives or the family members whom he has named in the advance directive, and also the concerned family members that he has written the advance directive. That is his wish if he becomes non-compos mentee. Further, the competent officer of the local government or the municipal corporation, municipality or panchayat will store this advance directive. That means the state government has to nominate such person so that they can keep a copy of the advance directive. As I mentioned, a copy will be handed over to the family members. AD, that is advance directive, becomes active once the executor, that means the person, becomes mentally incapacitated and is terminally ill. The nominated representative or the guardian will inform the treating physician about the AD if the person becomes terminally ill and is not in a position to decide. Now let's discuss about how to implement advanced medical directives if it is written by a person. Physician who is treating the person will be made aware of the advance directive. The physician will ascertain the terminal illness, that means he is in a condition which is not recoverable and patient has lost his capacity to decide or consent. Physician will contact the concerned family members whose name is written in the advance directive, and the physician will discuss the pros and cons of the advance directives, whether the euthanasia should be given, that is basically withdrawal of the treatment should be done, and he will document the information shared with the family members and the advance directive nominated representative, and he will take the consent from the NR or the nominated representative mentioned in the advance directive. The NR will give consent either to execute or not to execute. If the nominated representative refuses to give consent, that means the procedure will stop there only. If the nominated representative or the guardian gives the consent, then a 3-member medical board will be formed, which will be considered as primary medical board. Here, the treating physician himself and 2 subject matter expert of the concerned specialty will be chosen, and who will have 5 years of experience. In the earlier first decision, it was 20 years. Now it is 5 years. And this board will be considered as primary medical board. This primary medical board will examine the patient in the presence of family members or the nominated representatives, and they will submit their primary opinion in writing, either accepting the advance directives or rejecting the advance directive within 48 hours after formation of the primary board. If the primary opinion is implementing the advance directive, that is withdrawal of treatment, a secondary medical board will be formed immediately by the hospital. The secondary board will comprise of 3 members again. One is an RMP nominated by the chief medical officer of the district, and 2 more subject matter of expert, that is 5 years of experience. In these 3 members, none of them should be from the primary board. Secondary board members will examine the patient again, talk to the family members. They will assess the mental capacity of the person, whether he is suffering from terminally ill or not. They will discuss with the NR or the family members about the withdrawal of the treatment. They will take the written consent from the NR, and finally, they will submit their report within 48 hours. This will be considered as secondary opinion from the secondary medical board. And once the primary opinion and secondary opinion are in the same direction of implementing Advance Directive, that is withdrawing of the treatment, then the information will be given to the JMFC, that is Judicial Magistrate of First Class, relevant family members, and also the treating team regarding the withdrawal of treatment. Suppose if there is a conflicting report between the primary board and secondary board, what should be done? If the primary medical board declines to follow the Advance Directive, the executor, that is the patient or the nominated representative from the AD, can approach the hospital and request for secondary medical board. Or else the legal guardian, doctor, or the family member or executor or NR can approach the High Court directly under the Article 226 of the Constitution. The Chief Justice will constitute a division bench. The bench will form one more independent medical board. In this, there will be the medical board will consist of experts of 20 years of experience, such as cardiology, neurology, psychiatry, general medicine, nephrology, and oncology will be considered in this medical board. And that medical board will give the opinion. Based upon that, High Court will issue the notice to the respective people, and the decision of either honoring the passive euthanasia or not will be done. If there is no Advance Directive at all, this is the most common scenario in our country, my dear friends. If there is no Advance Directive, now the treating physician will ascertain, yes, this person is suffering from terminally ill and or he is in a persistent vegetative state. He has lost his capacity to decide, and by prolonging his treatment, he is going to suffer more. In such a situation, he will request a primary medical board after discussing with the family members. If the patient has the capacity to decide, he will take the decision. If the patient has in a clear consciousness, he says, I do not want the passive euthanasia, the process halts there only. If the person has capacity and he says, I want the treatment to be stopped, then the primary medical board will be formed. If the patient does not have mental capacity to decide, the primary medical board will discuss with the family members, significant others, with regard to euthanasia, that is passive euthanasia, and they will document in the file regarding the discussion, and also they will take a written informed consent from the family members. Once the decision is taken to withdraw the treatment, the secondary medical board will be formed. Secondary board will examine the patient along with the other family members in front of them actually, and both the primary and secondary medical board, if they are of the opinion to pull the plug, the information will be intimated to JMFC and the process will continue. Then the withdrawal of rights of support will be done. In case of there is a conflicting of medical report, then the family members or the treating physician can approach the High Court under the Article 226. Based on the report, the High Court will issue the order as I mentioned earlier. Now let's understand about the Advance Directive, how it is done. Here I'm going to summarize the whole thing which we have discussed till now. If there is an Advance Directive written clearly, signature of the two witnesses has to be done, and then notary certification, that is affidavit, has to be filed. Give a copy of the concerned Advance Directive to the family members, family physician, and it can be part of the health record. Give a copy of this AD to the designated authorities in the state. And this is how the Advance Directive is executed. Implementing the Advance Directive. If the Advance Directive is written and the patient has become irreversibly ill, in a persistent vegetative state is not in a position to decide. Advance Directive. Information will be given to the physician. Physician will form the primary medical board, and then if they give opinion, secondary medical board will be formed, and finally the intimation of pulling the plug will be given to JMFC. If the Advance Directive is not there, the physician will intimate the hospital, the primary board will be formed, secondary medical board will be formed, and finally the decision will be done. If there is a discrepancy in the primary and the secondary medical board, then the family members or the physician can approach the High Court directly. Let's understand and critique this judgment. Although this is a judgment which was discussed in 2023 January 24, it is a comprehensive again. It is a 5-judge constitutional bench. Apex Court is of the opinion in favor of passive euthanasia, against again the active euthanasia. It also clearly said right to life means right to life with dignity and right to die with dignity up to the end of natural life. No active intervention for death, that is, no active euthanasia is allowed. Right to autonomy means right to self-determination through giving an option of writing an advance directives. Will or the choice of the patient will be honored even when the patient is terminally ill and he has lost his capacity. In such a scenario, if he had written advance directive, that will play an important role, and that advance directive will indicate his will. Adequate checks and balances have been placed. Still, again, I feel there are excessive checks have been placed. 2 medical boards have been placed, and 2 medical boards, if they have to give an opinion within 48 hours, 4 days, even after that the JMFC has to be intimated, and finally within how many days of intimating the JMFC we need to pull the plug. These are the unanswered question. If the decision is taken after 10 days and the patient is on ventilator, who will pay for the patient's hospital bills? Although there is no registration of advance directive and the JMFC has been removed, no ambiguity is there. Appeal to High Court is still preserved. Euthanasia for those who have not executed advance directive is also being clearly laid out in this judgment. But however, there are certain negative points. Process continues to be lengthy. Again, 2 medical boards, that means 3 plus 3, 6 medical doctors will be spending time for a person who is going to, or who is wishing to die. 5 years of experience. And further, the High Court will form another medical board with 20 years of experience. Too many boards, lengthy procedure continue to exist. No procedures have been given to assess mental capacity in this. It is the biggest drawback here. So, what is the answer for that? The best is Section 4 of the Mental Health Care Act of 2017 talks about assessment of mental capacity, and relevant section of Section 81 of the Mental Health Care Act of 2017 talks about how the mental capacity to be assessed and a committee to be formed, and that committee has already given the procedure how to examine the capacity to consent. Further, the no components of mental capacity has been mentioned in this judgment. Mental capacity needs to be defined and assessment should be clearly laid out as per the Mental Health Care Act. Again, further the question is, do we require so many specialists? Are we wasting time in focusing on a person who wished to die? Instead, we should have discussed, invested our time in the people who are seeking treatment and the treatment is not available. Across India, lakhs of people every day run from one end of the country to the other end seeking for treatment. Many states do not invest in health. And you can see internal medical tourism. That means many patients from Northeast come to South. That is either Chennai, maybe Vellore, Bangalore hospitals, and many of them also consider going to Delhi. And many of the state are least bothered in investing in health. In such a scenario, discussing about this of withdrawing treatment, I think, was not required. The same time should have been invested in considering how we can make right to health a reality and making these states compulsory or obligatory to invest in health, so that our citizens who are requesting, who are requiring, who are running from pillar to post for treatment should get the treatment, and such state should be made responsible for taking care of their citizen. And if the patient has to travel from one state to another state, the state where the citizen belongs should take the responsibility and reimburse the treatment cost. That should have been the decision from the Supreme Court. Then that would be a boon for millions of people, for people who are suffering. And this, not only this, thousands of patients are waiting for ventilators, ICU beds, super specialty, surgery, organ availability. Many treatment are required. Unfortunately, many poor patients do not get this treatment. Wish the Supreme Court takes such a case suo moto and monitors every state what is happening. Even there is a single case who do not get treatment, should be brought to the notice of the Supreme Court and High Court, and they need to take the government to task. Ask what they are doing for their citizen, why they are not investing in health. And right to access to health care should become a reality, and this need to be made it obligatory and should be monitored by the apex court on weekly basis. Right to access health care would have been beneficial for many people rather than right to die with dignity. We are looking only at the civil and political rights. We are not discussing about economic, social, cultural rights, because it requires investment from the state. COVID has clearly exposed our healthcare system. It is so weak. And you go to any district hospital and also medical colleges, patients are many in number, especially in the government medical colleges. Even if there are buildings, there is no treatment available. Even if the treatment is available, it's very costly and it is not accessible to the poor people. If there is appropriate access to healthcare is there, that would have been a boon, my dear friends. Quality healthcare is the need of the hour at this point of time. Investing in public health should have been emphasized, mandated, monitored by the apex court, will be the progressive state. And that decision I'm waiting for, although there are various Supreme Court judgments with regard to emergency treatment as a right to health, but right to access for healthcare is a still long wished dream for millions of people who are waiting for treatment, waiting. Their number has to come for the surgery, cardiac surgery, neurosurgery. That is a still long way, my dear friends. Again, I would like to emphasize, COVID has taught us a lesson about our public health at this point of time. Rights-based healthcare under the right to life would have been a boon to India in form of right to access for healthcare rather than discussing about right to death with dignity. The reason being is the right to die with the dignity should have been only when right to access for healthcare becomes a reality for a last person in the last village, in a last mile. If the healthcare is available, and then if he does not want that treatment, then right to death with dignity should have been, because this decision is progressive and many decades ahead, my dear friends. That means, although this decision is laudable, exemplary, but unfortunately around 3 decades ahead of the current society, my dear friend. To conclude, if there is a terminally ill patient and he has lost his capacity, and if he has written Advance Directive, and if he has not written Advance Directive, the legal guardian or the physician will inform the hospital, and they form the primary board and the secondary board, and they will give the opinion with regard to passive euthanasia, If the mental capacity is present, the patient himself will tell whether he should take treatment or he will not take treatment, because the right to refuse treatment is a fundamental right. But now the question is, if he wants treatment and he does not have money, whether the state is ready to pay the money in the private hospital, that's a big question which is unanswered. Advance Directive, although the procedure has been made very simple, the requirement of independent two witnesses and a simple affidavit in front of a notary can be formed. The Advance Directive, copies to be given to the family members and the designated authorities, and the Advance Directive can be part of the digital health record, my dear friends. Implementing of Advance Directive is very simple at this point of time, but however continues to be a lengthy procedure. The Advance Directive need to be told with regard to the treating physician. Treating physician will form the primary board, secondary board will be formed, and they will inform the family members and the JMFC if they are pulling the plug, that is passive euthanasia. If there is any discrepancy between the primary and the secondary board, they can approach the High Court, which will go again decide based upon the merit of the case after forming a one more medical board. To conclude, our focus should have been improving the access to healthcare for all of our citizens. That is my personal opinion, although I appreciate the concern of the Supreme Court and also the petitioner who had talked about to die with dignity, right to die with dignity. But this decision is at least 3 decades ahead of our time at this point of time. Right to access for healthcare is the requirement at this point of time, and it is urgent. I urge the designated authorities to look into this matter. Passive euthanasia law should be introduced only when the last person in the last village, in the last mile, gains the access to healthcare, and when there is adequate quantity and quality of healthcare, then only right to die with dignity should be brought in. At present, available resources is not geared up to for passive euthanasia because we are not providing treatment for the people who require. And this judgment, again, I clearly say it's an amazing judgment, but many decades ahead of the present time. I would like to emphasize here one of the important decisions by the Supreme Court, National Legal Service Authority versus Union of India in 2014. There is a growing recognition that the true measure of a development of a nation is not economic growth. It is the human dignity when they are alive. That means not in the death, my dear friend. This is an amazing quote, again from the Supreme Court of India, my dear friend. Thank you very much for your valuable time. Stay safe.